Professor Penner, please.
Well, thank you very much to Simon and Russell for those preposterously overly generous introductions. But also thanks to the editors of the Singapore Law Review for inviting me to give this lecture. My hope is that in 45 minutes you won't regret that invitation. And but one thing I will promise you, I promise I won't do a Boris Johnson and lose my way halfway through and start talking to you about Peppa the Pig. All right, so the lecture title is Penalties, Not Punishments in Private Law. As the title hints, my aim in this lecture is twofold. First, to distinguish private law penalties from private law punishment. And second, to suggest that penalties have a clear home in private law, whereas the question about whether punishment is a proper function of private law or a suitable aim for private law is a much more difficult question. Now, I should begin by saying how I got interested in this topic. First, I was invited to make a contribution to this excellent collection. I'll show you the book in a second. It's called Punishment in Private Law, and it's edited by Elise Bant, our own Wayne Courtney, James Goodcamp, and Jeannie Patterson. And so this is a picture of it, in case you want to see it. I should also mention that the book has an absolutely wonderful foreword by Justice of Appeal Andrew Pun. It does a great job of introducing various papers, and we were all very flattered by his contribution. Now, when I thought about my contribution, which is supposed to consider punishment and equity, my thoughts returned to one of the first research projects in law that I was ever engaged in. When I was a law student at the University of Toronto Law School, I was a research assistant on a project on punitive damages headed by Michael Trebilco and Bruce Chapman. And that resulted in the publication of a paper called Punitive Damages, and the title's important, Punitive Damages, Divergence in Search of a Rationale. Now, as you can see from the title and the date when it was published, 1989, this was published in what might be called the formative stage of academic analysis of punitive damages, particularly in North America. Now, of course, the debate has moved on. I'm not sure whether the paper is very much cited anymore. But beyond that, in order to figure out what I thought about punishment in private law, more specifically with equity, I wanted to figure out what I thought about punishment in general, what punishment was in the first place. And in my review of the philosophical literature, it became quickly apparent that I had to get to grips with the distinction between punishments and penalties. So to get a running start on this question, I think one must first consider criminalization. Why do we create criminal offenses? And how are those who commit them to be dealt with? So let me begin by quoting a passage by Leslie Green, which I've quoted on more than one occasion. I've slightly modified it. I'm not going to tell you exactly how, it just brings out the thought, I think, a little bit better. So I'm quoting now. In jurisprudence, we are used to distinguishing primary legal norms, which he calls Plan A norms, that aim to guide conduct from secondary Plan B norms, norms that guide responses to conduct that fails to satisfy the primary norms. In areas like sexual interaction, however, it is not only the secondary enforcement, but also the primary obligations imposed by law that should be seen as Plan B, as fallbacks, morally speaking. Things are not going well, sexually or legally, when men need guidance from the legal duty not to commit rape. And the point is quite general. We also want people to avoid assault, to refrain from discrimination, and to deal fairly, not because of a lively awareness of the normative force of law, but because it would hardly occur to them to do otherwise. The state has a role to play in securing that smooth running state of affairs, but not only by instituting a legal duty of obedience. In some cases, the state is at its best when it helps shapes our social world in a way that is relatively invisible. Now, if it is successful, Plan A is good for everyone. Victor Tadros, helpfully points out and elucidates something that anyone with moral understanding should know already, that a crime blights the life of the perpetrator as much as it blights the life of the victim, perhaps more so. And it seems to me that the state has a role in securing that state of affairs when people don't commit crimes in the first place, by helping to secure a society wherein socialization, culture, education, and so on help to improve and certainly do not thwart our moral understanding, and helping to secure social conditions such that people are not systematically tempted to commit crime. The law as such, understood in terms of statutes, cases, and the legal process, may have relatively little to do in this regard. Now, let me set out what I shall call an assurance theory of criminalization. Although the assurance theory draws heavily upon expressivist and retributivist theories, it has a different primary emphasis. Assurance theory trades on the following fundamental idea. When a person maliciously victimizes another, a community cannot stand idly by. It must take steps to show that it takes the side of the victim. Indeed, for an assurance theorist, it is the moral obligation on any community to take, it is a moral obligation on any community to take the side of the victim over the perpetrator in some suitably expressive way. This is especially so in the case of serious violations, murder, assault, grievous bodily harm, plundering, frauds, and so on. A community is less of a community insofar as it fails to do this. Victims, in the absence of this taking their side, are treated as equal to or even less than the perpetrator who victimized them. For assurance theory, the public response assures members of a community that the interpersonal moral norms governing wrongdoing are enforced, not just enforced, respected and enforced. Without that respect and enforcement, their community is less of a community. What particular shape this public response takes in a particular community will naturally vary according to the social circumstances. In a very small, tight-knit religious community, the response might be by way of confession and repentance before a priest, who in this sense acts on behalf of the community of believers. But it is difficult for me to imagine anything but the more or less secular state taking on this role in modern pluralistic societies. In any case, one way or another, discharging this public obligation is one of the constitutive obligations of a community. Where there is complete or systematic failure to discharge this obligation, we have a state of barbarism. Now, notice the conceptual priority of taking the victim's side over the issue of punishment itself. This has an immediate payoff. It explains why those interested in penitential or restorative or reconciliatory responses to crime, even though they may abjure punitive responses, are on the same page so far as this goes. In other words, this assurance aspect of the criminal law is prior to the issue of how a community responds to criminal wrongdoing. It only requires that whatever response it is must provide the right assurance to upstanding citizens, assurance that their rights and lives are appropriately valued and respected in the communities in which they live. Especially for those of you who are interested in criminal law theory, I must distinguish the assurance theory account from a similar idea expressed by John Gardner, the great late John Gardner, which might be called the displacement theory of criminal law. He writes, and I quote, "The blood feud, the vendetta, the duel, the revenge, the lynching, for the elimination of these modes of retaliation, more than anything else, the criminal law as we know it today came into existence." For Gardner, this displacement function of the criminal law is one of its central pillars. Now, for an assurance theorist like myself, this displacement function is a conceptual requirement, not merely an empirical historical observation, if you want to take Gardner's view to be that way understood. Insofar as it replicates or reproduces, or worse, makes essential reference to private retaliatory motivations, the law of the state's response to wrongdoing is ruled out by the assurance account. The obligation to take the side of the victim is necessarily collective or communal. Not only can it not be discharged by an individual or any number of individuals, it cannot reflect their private motivations in seeking revenge or retaliation. Only some community representatives speaking as the voice of the community can discharge that obligation. Okay, so that covers my theory of criminalization, if you will. So what about punishment per se? When should we punish? Since punishment entails a setback to the rights of the wrongdoer, which is intrinsically bad. Now, notice I said intrinsically bad, not intrinsically wrongful. The short answer is that we should only punish where this is necessary to provide the necessary assurance to upstanding members of the community. I derived this idea from Alan Bridner's 1980 article, Retributivism and the Death Penalty, which I still think is one of the best introductions to punishment theory that you can find. So I really do recommend it. He was also my teacher at the University of Toronto, but that's not why I'm recommending it. In his conclusion to the article, he says, somewhat surprisingly, retributivism issues in a counsel of pragmatism with respect to the use of the death penalty. It leads to the Montesquieuian conclusion that the penal code is best which suits the spirit of the people, by which is here understood the system of life-organizing beliefs regarding the foundation of human value. Not to be confused with this result is the conclusion of Beccaria. Beccaria being, for those who aren't familiar with him, one of the most famous early utilitarians writing about punishment. So not to be confused with this result as a result of Beccaria, who thought that the scale of punishments ought to be relative to the level of civility of the people, the more savage requiring stronger treatments. The question legislators must ask is not how much punishment is needed to deter potential criminals in the present state of society, but how much is needed to reassure decent men in the present state of their self-knowledge. End quote. Now, this may be, I hope this is a fair paraphrase, but to paraphrase this from the perspective of an assurance theorist, the law's response to criminal wrongdoing must be such as to assure members of the community that it does genuinely take the side of the victim. And depending upon the self-understanding, sophistication, and empirical security of the community, the appropriate response will vary. In some cases and societies, only a setback to the criminal's rights, that is, punishment, will do. Now, contrary to what Alan Bridner said in later writings, assurance theory does not necessarily justify responding to crime by punishing as a general rule. What it requires is the general availability of the state's power to punish. Sometimes turning the other cheek is a superior means of vindicating right and may fully provide for the necessary assurance. And there are cases where, though deserved, it would be just wrong to punish. The state should exercise mercy. A writer on this, McCloskey, provides, to my mind, a telling example of the criminal who has already greatly suffered in blinding himself in attempting to blow a safe. Okay, so we now turn from the somewhat vexed task of to the somewhat vexed task of distinguishing penalties from punishments. But first, I think the distinction is a familiar and intuitive one. So first, following Joel Feinberg, who is one of the earliest writers on this, we can say that punishments typically express condemnation, while penalties, such as parking fines, do not. Another thought is that we punish true crimes, but only penalize regulatory offenses. Thirdly, although not punishments, penalties address wrongs, behavior which violates the rules. They are not to be treated as license fees or taxes on the behavior in question. And this point can be seen in the law itself. Someone who intentionally breaches a regulatory offense may indeed be liable to punishment. For example, in the case of a repeat offender who may be subject to higher and higher fines. In other words, a person who treats the fine as a tax or a license fee willingly disregards the intention behind the fine, which prohibits someone, the purpose of which is to prohibit something rather than licensing it at a cost. So some people find income tax punitive, right? But the purpose behind income tax is not to cause you not to earn money. It's just, a means for the state to raise money. The state is not trying to prevent you or fine you for doing your job. Now, as regards penalties, now I want to say that one of the themes of this literature, and I subscribe to it, is that it's difficult to find a very sharp distinction in all cases between penalties and punishments. This takes some analytic work, and I hope the penalties that I shall go on to identify in private law will convince you that that distinction can be, at least in certain cases, properly drawn. As regards penalties in private law, I shall restrict my attention to rules that regulate what Hart called the facilitative side of private law, the private law that confers powers upon people to organize their affairs with others. The obvious examples are the laws of contract, property agency, wills, trusts, and so on. So I will not be dealing with any remedies in the case of the law of torts. I cannot go into this in any detail here. All I should say is that I do not regard the remedy of damages which compensates somebody for loss caused by a tort to be either a penalty or a punishment. Before turning to the private law itself, I think we can sharpen our intuitions about the penalty-punishment distinction by looking briefly at the rules of the game. And the game I have chosen, hopefully just because I think most people have a reasonable familiarity with it, is association football. Doing so is illuminating, I contend, because it shows that a penalty is imposed where an individual takes an advantage or is liable to have an advantage outside of the rules. And the intended effect of the penalty is to strip him of that advantage. But where no judgment follows that his behavior is unsportsmanlike or malicious, mala in se, that sort of thing. There is no condemnatory intention, and as I said, mens rea is irrelevant. Another way of putting this point is that the rules disentitle the wrongdoer to the gain he did or might have acquired outside the rules. In my view, being sent off for the duration of the game, that is getting a red card, is a punishment directed to the individual player for malicious or deliberate misbehavior deserving of condemnation, which can also be characterized as unsportsmanlike conduct. These are clearly mens rea offenses. Red cards doubtless also have collateral penalizing effect on the team, depriving the team of that player's unique skills for the duration, in the same way as imprisoning a trader for insider trading doubtless also penalizes her firm, depriving it of her services. These collateral penalizing effects may indeed be intended. For example, in association football, a player sent off cannot be replaced, so his team must carry on one player short for the duration of the game. Now, as to penalties, as I've proposed, penalties are instituted to prevent teams from getting advantages outside the rules of the game, but which are not condemnatory. Vigorous play often results in such infractions, in particular fouls by one player on another, but also in terms of non-foul rules, such as the offside rule in football. The typical response is for the play to be halted and some advantage awarded to the other team. A free kick, a corner kick, a throw-in, and so on are typical in football. And most seriously, of course, there is a penalty rule, giving the foul team the right to nominate a player to take a shot on goal from the penalty spot. And that's typically awarded when a player is fouled in the opposing team's penalty area. Now, I've argued that penalties strip a team of what would otherwise be an advantage acquired outside the rules of the game. But we should be judicious about this idea and the way that rules are applied. As in other cases of rules, we must distinguish between the justification for a rule and the requirements of the rule itself, how it applies in individual cases. This will be important when we consider game stripping penalties in private law. In the case of penalties in games, the rules providing for them have the general justifying aim of making sure the game is played by the rules, thus ensuring that players who would gain advantages by breaking the rules do not do so, as a simple matter of fairness. A player who attempts to pass the ball to an unmarked teammate in a scoring position, but sails the ball out of the pitch, gains no advantage by putting the ball out of play in this case. But the other team is still awarded the throw-in. Perfectly justifiable general rules often apply to cases where the justifying purpose is not directly applicable. Thus, it seems to me that at a very high level of generality, penalties fall within a system of advantages and disadvantages. That is, penalties are part of the regulatory framework of some activity to ensure that the individuals do not acquire advantages outside the rules. Now, there are two further issues which I must address before moving on to consider some examples of private law penalties. And the first has to do with the relationship between punishments and penalties and the idea of discretion. Now, clearly there is no analytic or conceptual requirement that punishments are subject to discretion in terms of their application along the lines of principles of sentencing followed by judges in criminal cases. As is well known, in the early common law, punishments for felonies were essentially automatically applied when the offense was established, and there was only one penalty, the death penalty. Of course, in the last century and a half, it became conventional that a range of punishments was available to the judge, and there were principles of sentencing by which he adjusted the punishment to fit the gravity of the crime and the particular circumstances of the criminal defendant. So we might say that as a matter of good normative practice, what we ought to have, when it comes to punishments, we believe that the person imposing the punishment should have discretion in determining a punishment from a range, whereas we tend to think that penalties, on the other hand, apply more or less automatically. Now, I think there is something in that, even if there are cases where an adjudicator has some discretion in adjusting the extent of the penalty. The case of games tells us that typically or normally, penalties are just a matter of stripping the wrongdoer of an advantage outside the rules. You just don't get that advantage. And it doesn't matter how big or small the advantage is. You just stripped of it automatically. And this is a point that I'll return to when we talk about individual private law penalties. The second issue I want to raise here is whether or not how someone feels about their being penalized or punished is relevant to determining whether a punishment or penalty has been applied. When I presented aspects of this work in other venues, more than once I've been told that whether something is a penalty or a punishment is in the eye of the beholder, where the beholder is the person who is suffering it. My view is that this is not right, though I do understand that the feeling of the sufferer may be indicative at times about whether something amounts either to a punishment or penalty. The reason I disagree with the outlook, though, is that when it is relevant for determining whether something is a punishment or penalty, the first thing we must look for is the intention of the person or the body who creates it, whether the legislature or the judges who develop judge-made law. It's their primary intention about what they are intending to do that determines whether they are intending to punish or merely penalize. I'm now going to move on to talking about some private law penalties. Finally, you may think. So I apologize if that was an overlong introduction to the topic. But before undertaking this work, I never realized, I never really thought about there being penalties in private law. But once I did do this work, it seemed to me that if you look, they seem to appear fairly frequently. Now, I'm very mindful of the famous quip by the great philosopher Mark Twain, which is, if you have a new hammer and you like the use of it, everything begins to look like a nail. So I hope that in undertaking this survey, I have not fallen foul of the wisdom in that statement, such that I seem to be seeing penalties everywhere in private law, in particular where they are not. So you must judge whether you find these examples compelling, but I hope that you do. I'm going to start first by looking or considering some civil procedure rules. Now, you may quibble with me about whether or not the rules of civil procedure are really part of the private law as we normally understand it. But I'm going to treat it as part of private law for my purposes here, because we're concerned with private law litigation. And I should mention just two such rules: limitation rules and rules regarding the award of costs. It seems clear to me that limitation rules impose a kind of penalty. A prospective litigant who doesn't bring his claim in time loses the advantage of having a right of action which a court must adjudicate. Or rather, the rule gives the defendant the power, by pleading the statute, to assert a complete defense to the claim, which but for the rule, she would not have had. But this is clearly not a punishment for wrongful behavior. There are, of course, in particular, sorry. So there are, of course, reasons for the rule, limitation rules. In particular, they are partly so the prospective plaintiff is not advantaged or the defendant disadvantaged because of all the issues that arise with the proof of stale claims. To my mind, the limitation rules reside clearly within what I've called earlier a system of advantages and disadvantages, part of the regulatory framework of some activity. The activity here being private law litigation. The other example here is that of cost orders. There is a normal rule in Singapore and elsewhere in the non-US common law world that costs follow the result with well-established principles of taxation. But there are also principled deviations from these rules. In particular, if the conduct of litigation by one of the parties is worth penalizing in some way. In some cases where costs which would normally be awarded are denied, or where costs on an indemnity basis are ordered. The judge may express not only disapproval, but annoyance and exasperation with the party addressed, but this doesn't require a finding of mens rea, some malicious intent on the part of the party addressed. More typically, at least as I see in the cases, it is more like a finding of professional lapses on the part of counsel, or unreasonable, uncooperative, or dilatory conduct on the part of the litigant himself, especially where this has led to what the judge regards as having wasted the court's time. Again, the power to vary cost awards away from the normal rule can probably be regarded as a penalty, I think, within the regulatory framework governing private law litigation. Moving on now to what you might call the private law proper, I want first to consider the Forfeiture Rule. As far as I know, the Forfeiture Rule has not been applied in Singapore, although it has been mentioned in a couple of cases. Okay, here's the Forfeiture Rule. Where A unlawfully causes the death of B, and because of B's death, A will acquire property as a legatee of B, or as a successor under the rules of intestate succession, A's interest will be forfeited. Where A and B are joint tenants of property, the joint tenancy will be regarded as severed so that A cannot take advantage of the rule of survivorship. Now, the rule clearly applies in cases of criminal offenses, most obviously in the case of murder, manslaughter. It also applies to the offense of procuring or assisting the suicide of another. Now, the unassailable basic principle behind the rule was famously stated by Lord Justice Fry in Cleaver and Mutual Reserve Fund Life Association in 1892. The executors of the deceased, who had been murdered by his wife, argued it is against public policy to allow a criminal to claim any benefit by virtue of his crime. And Lord Justice Fry said, the principle of public policy invoked the principle of public policy invoked is, in my opinion, rightly asserted. It appears to me that no system of jurisprudence can, within reason, include among the rights which it enforces, rights directly resulting to the person asserting them from the crime of that person. If no action can arise from fraud, it seems impossible to suppose that it can arise from felony or misdemeanor. This principle of public policy, like all such principles, must be applied to all cases to which it can be applied, and I emphasize this last bit, without reference to the particular character of the right asserted or the form of its assertion. Now, I would contend that this is a judge-made penalty, which is clearly justified. As a penalty, it denies a right that the perpetrator would otherwise be entitled to because of her mode of acquiring it. The mode of acquiring it was clearly, if not flagrantly, outside the rules. But moreover, I would assert it is not a punishment. There is no conceptual connection between the value of the right and the gravity of the wrong. It is not a measured setback to rights in the way we think punishment ought to be. It doesn't matter if the interest at stake is worth $100 or $10 million. Moreover, the rule was not traditionally subject in its application to any judicial discretion. In particular, it was not and should not be seen as an added punishment the private law court imposes upon the perpetrator, additional, that is, to whatever true punishment the offender received by being sentenced to in criminal law proceedings. Although judges have suggested this, most famously the dissentient judge in the US case made famous by Ronald Dworkin, Riggs and Palmer. Now, the rule has been modified by statute in the UK. By virtue of Section 2.1 of the Forfeiture Act 1982, judges have a discretion to make an order modifying the rule's effect. The nature of the discretion is set out in Section 2.2, which provides the court shall not make an order under this section modifying the effect of the forfeiture rule in any case unless it is satisfied that, having regard to the conduct of the offender and of the deceased, and to such other circumstances as appear to the court to be material, the justice of the case requires the effect of the rule to be so modified in that case. Now, my worry about this statutory intervention is that by requiring the court to have regard to the conduct of the offender and of the deceased, this will inevitably lead to regarding the rule as a kind of punishment. For this regard seems very much like the kind of thing relevant to criminal sentencing. Now, you must read the case of Dunbar and Plant, decided about 10 or 12 years ago, a decision of the English Court of Appeal. You must read that case for yourself and decide for yourself. But it does seem to me that in applying the two discretion, the court did seem to be treating the forfeiture rule as a form of punishment and assess the blameworthiness of the offender in deciding whether applying the rule would be disproportionate. Now, from the tone of my voice, you can probably tell that I think this was an unfortunate development. But let's move on. Let me now consider the illegality doctrine. The normal rule is that the private law court is to administer, the normal rule is that the private law court is to administer justice as between the parties in dispute before it. The illegality doctrine states that where a party founds his action upon a morally turpid cause, the court will not provide him a remedy. I would argue that in its traditional formulation and application, this was a penalty. The court did not inquire into the seriousness of the wrongdoing, though the rule had exceptions, such as the not in peri delicto exception. Exceptions were considered at length by the Singapore Court of Appeal in the recent case of Awkward trading. The doctrine is famously stated not to be a rule of justice between the parties, but a rule of public policy by which neither party to such an illegal action will have the justice of their claim inter se adjudicated. In its recent Awkward decision, I think the court's founding of the illegality doctrine on the stultification principle, roughly that the nature of the illegality must be such that if the court were to ignore it and hear the plaintiff's claim on the merits as between the plaintiff and the defendant, other surrounding policies and principles of valid extant law would be stultified or thwarted. This does not turn the application of the principle from a penalty into a punishment. The fact that the inquiry may need to be both fact sensitive and sensitive to more than one policy or principle of the surrounding law does not, to my mind, make the judge's application of the rule discretionary. By contrast, I would contend that the majority's new range of factors approach in the United Kingdom Supreme Court decision in Patel and Mirza very much raised the possibility that in the UK, the application of the doctrine is understood to be a matter of punishment, or at least moving in that direction. Two of the range of factors to be taken into account bolster this assessment. One is how serious a sanction the denial of enforcement is for the parties seeking enforcement. Another is whether denying enforcement will act as a deterrent to conduct that is illegal and contrary to public policy. Now, for the record, I will say that I am not a deterrence theorist of punishment. Whether something deters is an empirical matter that cannot be controlled by the person creating the penalty or setback or punishment. Right? It's a huge sociological question about the extent to which criminal law sanctions actually deter, the extent to which they deter, and so on and so forth. But obviously, the concept of deterrence figures very, very largely in many discourses regarding punishment. So the only point that I'm trying to make by citing this particular factor, whether the enforcement will count as a deterrent, is this points us all very clearly to certain views on the nature of punishment. Okay, moving on to another case from private law, deposits and the penalty doctrine. So the initial question is, should private law parties be able to create penalties for each other under the law of contract? As a matter of authority, until recently, the answer would seem to be yes. A party can insist upon what is called sometimes an earnest of performance. That is a deposit, which is forfeited if for some reason the counterparty is unable to perform. That clearly strikes me as a penalty, not a punishment. It has nothing to do with moral failings on the part of the counterparty, nor is any kind of mens rea relevant. It also operates automatically. Though if you want to frame it in punitive terms, you could say that the party introducing the term has a discretion to lower the punishment, not raise it, lower the punishment by waiving it in part or completely. But here is a clear distinction between the penalties we've so far discussed, as well as the fiduciary no profit rule, which we shall consider in a minute. In these cases, the right that is lost or forfeited in those cases, I mean forfeiture, the right that is lost or forfeited is natural in the sense that it is not set, that is determined by defining some monetary amount by agreement under a contract. For example, the forfeiture rule does not set some predetermined amount, which constitutes the extent of what the killer will lose. In view of this, it is perhaps not surprising that the contract doctrine known as the penalty doctrine has recently been held to apply in the UK to deposits in the United Kingdom Supreme Court case of Cavendish Square Holding and McDessie. But that, I would contend, does not turn it into a penalty rather than a punishment. It just sets reasonable limits on the penalties contractual parties may impose upon one another. Now, I have not been able to properly consider in full Wayne Courtney's excellent chapter on this in the book I showed you earlier. But I do have a reflection upon something he says in his conclusion. Again, I quote, "As the law stands in England, the plainest objection to contracting parties," forgive me. "As the law stands in England, the plainest objection to contracting parties being allowed to punish each other is doctrinal coherence. If punishment is not a function of contract law and punitive damages are unavailable for breach of contract, parties should not circumvent that policy by express agreement. Were the law to change, as it has in Canada, other objections come to the fore. These include that the innocent party lacks authority to punish, that there are insufficient procedural protections for the contract breaker, and that for substantive consistency or deeper policy reasons, punishment must be determined by an agent acting on behalf of the state." Now, in what I've said before, it's clear that I entirely agree with the sentiments expressed here, but I do not think they apply to penalties as opposed to punishments. To the extent that deposits count as the former, their regulation, though I wish it was not under the penalty doctrine, which clearly seems to regard the penalties it regulates as punishments, does not strike me as problematic. But the further lesson I hope to draw here is that if we do not distinguish clearly between penalties and punishments, we are unlikely properly to understand the issues about substantive consistency and whatever deeper policy reasons should figure in the court's deliberations. Okay. So finally, I turn to bribes, unauthorized profits, and the no profit rule. I've written about this topic extensively, and the no profit rule is one of the main examples of a private law penalty that I examined in my paper for the essay collection, so I shall not go over that again here. But there are some aspects of this form of gain stripping penalty which I want to emphasize for analytic clarity, points which I think bear repeating. The first is that stripping a person of a bribe does not require finding them to be a fiduciary, despite the way this liability is typically framed in the textbooks and the cases. It shouldn't be framed this way. A person is bribed when he is offered a benefit to act disloyally in relation to another. A hitman who receives money from A to kill B is not being bribed. He's just being paid to commit a wrong against B. A bribe can be made to anyone subject to a duty of loyalty, and this includes all employees, whether or not they are fiduciaries to their employers. The basis of the duty is the fact that in relying upon or trusting in a colloquial sense, not trust law sense, in trusting or placing faith in the employee to deal with the employer's property and carry out his employer's instructions, the employer places the employee in a position that enables the employee to take advantage of those factual circumstances. That position differentiates him from a mere stranger to the employer, which is why he has a duty of loyalty. Stripping the bribee of the bribe is a private law penalty because this is a clear case of gain stripping for committing a particular kind of wrong, a disloyal breach of obligation. As between the bribee and the one to whom she owes the duty of loyalty, the latter is entitled to the value of the bribe only for the reason that the bribee is disentitled from taking or keeping it. Now, moving on to true fiduciary law, I want to discuss briefly the profit opportunity rule and distinguish it from the no profit rule. Here I want to contend that the application of this rule is a penalty. The no profit rule is a penalty. But first I must distinguish it clearly from the fiduciary profit opportunity doctrine, which is nothing of the kind, but with which it is not uncommonly elided. Notice that in the case of the profit opportunity doctrine, the plaintiff principal has a range of remedies all reflective of her antecedent entitlement, as between herself and a fiduciary, to the fruits of that opportunity. She can sue for equitable compensation for loss. This is essentially a kind of loss of a chance claim, requiring her to establish on some reasonable basis that she would have gained what she would have gained had the opportunity come her way as it should have done in the first place. Alternatively, she can seek an account of the fiduciary's profits for exploiting the opportunity himself, which are reflective of, but may not be identical to, her own loss from not receiving the opportunity. Finally, where she can identify assets that represent the fruits of her false fiduciary's exploitation of the opportunity, she can claim that these assets are held by him on trust for her. Perhaps this is something of a side issue, but I do want to point out something about the case where the fiduciary is found to hold assets representing the fruits of the opportunity on trust for his principal. To take just one of a multitude of cases, it does seem to me sometimes that there's almost a pastime amongst company directors to divert profit opportunities away from their companies. The cases are endless. Okay, so consider the Singapore High Court decision in High Tech Builders and Tan and Leong, decided in 1995, as one of a multitude of cases. A company director diverted a profit opportunity which he should have pursued if he pursued it at all for his company. He pursued the opportunity himself, diverting it to a company he controlled called Evergrande. Of course, he was liable to account to his company. At paragraph 69, Mr. Justice Warren L.H. Koo said, since the benefits of and arising from contract 220 belong beneficially to the plaintiffs, Evergrande is in the position of a constructive trustee in respect of those benefits vis-a-vis the plaintiffs, and all appropriate remedies and equity in respect of those benefits, including accounting for the profits received or receivable from the contract, are available to plaintiffs against Evergrande. This finding is indisputably correct. What I want to question is the idea that the profits are held on constructive trust. To my mind, they're held on express trust, since the director had an express obligation to pursue the profit opportunities for the company. That he diverted the profits elsewhere does not mean that the company was not entitled to them. They were, because they were the fruits of an opportunity he had a prior original obligation to obtain for the company, as the judge recognized. Compare this with a simpler case of a trustee who sells a trust asset and banks the proceeds in his own personal bank account instead of in the trust bank account. Of course he holds these assets on trust. But will we want to say he holds them on constructive trust? The proceeds are bound from the outset by the beneficiary's interest in the trust assets and whatever traceable proceeds derived from them. Their interest in the proceeds is an express trust interest. To put this another way, when the company wants an audit, the director holds the proceeds on trust, or when the beneficiary does the same, what they essentially want is a declaration that the proceeds are theirs, not a remedy which imposes a trust over property which would otherwise be the property of the director or the trustee. The upshot of these considerations is that, unlike the no profit rule, which I'll shortly get to, which strips the fiduciary of a gain to which her principal was not antecedently entitled, the fiduciary in a profit opportunity case is not being stripped of some gain that came to her beneficially. The gain was never hers beneficially to begin with, so stripping her of it cannot amount to a penalty. So, the fiduciary no profit rule, which I shall treat very briefly here. The rule does impose a penalty because it strips the fiduciary of what might be called an unauthorized incidental profits to which her principal was not antecedently entitled. That is, the fiduciary, unlike in the profit opportunity case, was not under any obligation to acquire such a gain for her principal. I shall merely address one clear example. Consider the example of a trustee who votes the trust's majority holding of company shares to appoint himself to the board of directors. It is trite law that unless otherwise allowed by the trust instrument or via the fully informed consent of the beneficiaries, he must account for his director's fees. What is important to realize is that the beneficiaries have no antecedent right to these director's fees, as if, because of the trustee's majority shareholding, the beneficiaries are entitled to require the trustee to vote himself onto the board just so he can add the director's fees to the trust assets. That's a preposterous notion. The trustee has an obligation, if he thinks it necessary to protect the beneficiary's interest, to appoint someone to the board to look out for those interests. If he identifies a third party who in his judgment is the best person for the job and at arm's length from him, say an accountant, and appoints her, she will be entitled to the director's fees and the beneficiaries have no cause for complaint. But let us suppose the trustee concludes that he would be the best able to serve the beneficiary's interests by appointing himself to the board. Well, now we have a clear conflict of interest because the gain, the director's fees, he will acquire by doing so. He cannot do so unless he resolves the conflict first. He can get the fully informed consent of the beneficiaries. Strictly speaking, the beneficiary's consent does not remove the conflict, but simply authorizes the trustee to proceed anyway. But it resolves the conflict in the sense that it is no longer an impediment to the trustees going ahead and retaining the director's fees if the beneficiaries so agree. Okay, so that is as much as I'm presently able to say about private law penalties. But as I said in the abstract, I was going to return briefly to the issue of punitive damages. So I'm not going to discuss the current doctrine regarding punitive damage, whether here in Singapore or elsewhere. I'm just simply not learned enough to do that, and that would be the subject really of an entirely different lecture and might be a book-like treatment. So my remarks would be schematic and in some sense theoretical, if I can put it that way. I might as well start by saying, as a matter of moral justification, I start out with a strong resistance to punitive damages, and the basic ideas are obvious. One cannot derive a right to punish, as far as I'm concerned, under the assurance theory as a matter of private law, since the right to punish is a collective public right. A private law cannot award such a right to punish as a private law court. This is not just a matter of doctrine or competence, but a conceptual matter. Nor can the private rights of the plaintiff generate any right to the benefit of a punishment. Relatedly is the idea that the plaintiff in such cases secures a windfall unrelated either to a duty of repair she is owed or to a primary private law duty of performance. And this has enough, to my mind, has nothing to do with the quantum of the award, whether the award comes to the plaintiff as a windfall, rather as a public measure of condemnation. A punishment cannot allocate the benefit of a punishment to any private actor. In that respect, punitive damages privatize punishment, and that alone brings them worryingly close to a form of private retaliation, which is one of the purposes of the assurance theory of criminalization, to abjure. But it gets worse. As the holder of a right of action, it is up to the plaintiff to prosecute or not such right. Consider settlement. As illustrated by Catherine Sharkey in her contribution to the collection of essays I've shown twice already, the power to enter into settlement can largely determine the punitive fate of the defendant. Far from being a truly public sanction, this brings the whole matter as close as can be to state-backed private retaliation for personal gain. Now, there's one further thing I want to mention about punitive damages by referring to the just marvelous essay by Andrew Roberts and Megan Richardson, also in the collection. And this has to do with the operationalization, how to make punitive damages thinking operate in the private law context. So they say, and I quote, regarding the availability of punitive damages, they say, and again, I quote, they might be used to address blind spots in the criminal law, imposing punishment for the kind of serious breaches that might expect to be criminalized but have not been. They provide a means of overcoming the criminal law's inertia. The criminal law is often slow to respond to emergent threats. They provide individuals with the power to ensure that the conduct that has been criminalized is punished where the institutions of the state are either indifferent to the wrongdoing or lack the resources to respond to it adequately. Now, it seems to me that if we're going to have genuine punishment in the private law via punitive damages, then their availability must reflect or integrate with how the criminal law is itself responding to the wrong in question. But how is a plaintiff to bring to bear the mentioned considerations when seeking an award of punitive damages? And how is the defendant to reply? More importantly, consider the poor judge. I think it would be a brave judge to find, and on the basis of what facts, given the limits of the doctrine of judicial notice, would be a brave judge to find as one of the grounds of his decision to award punitive damages that currently in his jurisdiction, there are blind spots in the criminal law, that there is inertia in the criminal law, which translates, I think, into the claim that the legislature, insofar as criminal law is concerned, is being slow or inefficient in addressing wrongdoing in the community. Or finally, that the institutions of the state are either indifferent to the wrongdoing or lack the resources to respond to it adequately. So I found the word. So I just find these considerations very difficult to operationalize in the context of private law litigation. Now, my time is up. So I was going to say, make some comparisons between punitive damages and aggravated damages, which I do support and I think are preferable, but I won't trouble you with that now. So let me conclude by saying, I expect many of you, especially those of you on the bench in the profession, will be unsatisfied with much of what I have said. I am myself. These are tricky issues. They require more thought than I've been able to give them to in this lecture. But I do hold that with a bit of nous and legal acumen, the difficulties I have pointed to are susceptible to resolution on a careful, case-by-case basis, which I continue to think of as the practitioner and judge-led genius of the common law. Thank you so much for your attention.